also expanding affordable housing as well as strengthening and enforcing the rights of tenants. We provide technical assistance and policy support on a range of housing issues to legal services as well as other housing justice advocates nationwide. And we have worked with thousands of advocates and housing providers on compliance with the Violence Against Women Act's housing protections, as well as implementation issues. So thank you uh, for having me present to you all today, and I'll pass it to Renee.
Hi everyone, really great to be here. My name's Renee Williams, she, her pronouns, and as was mentioned, I am with the National Low Income Housing Coalition. And National Low Income Housing Coalition is an organization that focuses on the housing needs specifically of extremely low income people. And as folks know, that is a big issue, not only today, but has been an issue for a long time. And so this is a very timely conversation because fair access to housing, as we're going to talk about, is very important, particularly for people who are trying to access and stay in housing. And I, Although I'm at the National Income Housing Coalition now, I worked for 9 years at the National Housing Law Project, where I also did a lot of work around the Violence Against Women Act as well as Fair Housing Act, and just really excited to be here. So, thank you. Apologies. I'm going to take us now into the presentation goals for today. And again, just really excited and really just at the jump want to mention to folks that people should definitely feel free to drop questions in the chat. If folks have clarifying questions, we want this to really be useful and practical to folks. So our goals today are folks who are attending will be able to identify protected classes under the Federal Fair Housing Act and recognize when it applies to survivors of human trafficking. We'll also talk about the rights of survivors under the Federal Fair Housing Act and be able to discuss, issue spotting and recognizing discriminatory housing practices. Participants will be able to identify and recommend the appropriate enforcement options for survivors, and also just thinking creatively about advocacy-based interventions, as well as administrative complaints and litigation options. And then finally, we will talk at the end about the Violence Against Women Act and how that applies in certain cases to survivors of human trafficking, and we'll understand VAWA's core housing protections. Next slide, please. So the way that we've set up this conversation and this training today is to really base it in scenarios. So as I mentioned before, that we can really speak to issue spotting and, understanding how these protections may arise in practice. So we're going to focus on Mara. And as we go through, we're going to have a number of scenarios about Mara and ask you some questions and really just want to facilitate a lot of discussion in the chat and through polls. So Mara is relocating to a job in a new city. So she wants to start a new job, and she is a survivor herself of sex trafficking. She's experienced housing insecurity in the past and is not making a lot of money. So she's having to do things like rideshare app, gig economy type work. Her credit is also not great. So, as folks know, a lot of survivors have issues with credit. And as a result of what she experienced as a survivor of trafficking, she also has PTSD and a diagnosis with that. So, all of that taken together really limits her housing options. So, as I mentioned before, it's really, really important for folks to be able to understand all of their rights and protections so that they're able to have equal access to housing and be able to stay in their housing. So Mara is housing insecure. She couch surfs and is finally able to find an apartment that allows her to have reasonable commute and if she's able to also do gig work, she can actually make her rent. But again, she is not housing secure. Next slide, please. All right. So the scenario one. Um, Mara has been living in her home that she just was able to get, and again, she's not housing secure, so this was a difficult process for her. But unfortunately, there was a break-in in the building over in the next apartment complex, so this was very rattling to her and actually exacerbated her PTSD. And, she's not able to sleep. She's not able to eat regularly. It's really interfering with her life. Mara recently noticed that building staff, will oftentimes come and knock on the door to drop off various notices about things like repairs. And every time that happens, this really triggers Mara's PTSD. And, she really feels unsafe when that happens. And so Mara, is really struggling and would really prefer the notices to be delivered in a different way, perhaps when she's not home. So, what are Mara's options? And I believe we will have just kind of ask people to put some options in the chat. Don't be shy. And I would just encourage folks, don't think about legal requirements, just really kind of think about, if Mara, yeah, okay. Um, so we have something to chat about, have a conversation with the property manager. Um, that's great. Alternative communication, request notice via email. Um, these are all really good suggestions. Any other suggestions? Excellent. Can we go to the next slide, please? All right, and I'm going to pass it over to Natalie. And so, folks, just keep those responses in mind because I think I'm going to revisit them when we talk about reasonable accommodations. But Natalie, go ahead.
All right, thanks, Renee. We can go to the next slide. All right, so the bulk of our presentation today is going to be talking about the Fair Housing Act, and this is a federal law. It was passed in 1968 as part of the Civil Rights Act. And the importance of the Fair Housing Act is that it prohibits discrimination in housing, both in transactions involving the sale of housing as well as renting housing. And it has broad application. It applies to all dwellings, so both public housing as well as private market housing. There are some carve-outs, which we're not going to get into in detail today, but they're fairly limited. And so that's one of the reasons why this particular law is so important, because of its wide coverage. Next slide. So the Fair Housing Act prohibits discrimination based on 7 protected categories or classes, as they're called in the law. So it prohibits discrimination in housing based on someone's race, color, national origin, religion, sex, familial status, or handicap is the language that's used in this statute. Remember, I said this was originally passed in 1968. The provision protecting people with disabilities was added in 1988. And so that's the reason for the antiquated language. And familial status, in terms of protected classes, refers to protection for people or families with children. Um, we can go to the next slide. And one of the important pieces of the Fair Housing Act, and a place where the majority of the complaints that are filed with the Department of Housing and Urban Development are around disability discrimination. And also, so one, this is an area that there are a lot of complaints around, but also it's one that you may run into, especially serving survivors in terms of the protections. The other thing that I will just note is we know that the people that we are working with and advocating on behalf of are not just one identity. And so it's just important that, while we talk about specific types and classes of discrimination, that we recognize that it is not always clear what the basis for discrimination may be. So, when it comes to disability discrimination, what the statute defines what a disability is, and that refers to a physical or mental impairment that substantially limits one or more of a person's major life activities. So, major life activities like working, talking, walking, driving, those types of things. So, who is a person with a disability? So, the Fair Housing Act defines a person with a disability as someone who has a mental or physical disability, someone who has a record of such impairment, or someone who is regarded as having an impairment. So, in other words, someone who's treated like they're a person with a disability, even if they don't actually have a diagnosed or record of a disability. Um, and then one thing to note is that disability includes individuals who are in recovery from substance abuse. So they are covered as people with disabilities. However, it does not protect someone who is actively or currently abusing um, us, alcohol, drugs, or some other substance. Next slide. So now we get to our first poll, and we're going to have you think back about Mara and what you know about her so far. So based on our scenario, is Mara a person with a disability? So your options are yes, no, or I don't know. And just to help, remember in the fact pattern, what we know so far about Mara is that she's been diagnosed with depression and PTSD. So we'll give folks a moment to respond to the poll. And you should have a poll question that's popped up. Sade, can you let me know when we've got majority of
Yeah.
folks responded?
We got about 8 of 18, so 44%.
Okay. Let's,
Just
and
a
I
couple
see
of
we've
people.
got one person in the chat. So that's fine. And then let's see if we can get a couple more responses before we close the poll.
While we wait, sorry, I have a question.
Sure.
No, it was just you said earlier that those who are in recovery could be considered somebody with a disability, but those who are actively using drugs at that their drug usage wouldn't be considered a disability.
That's correct.
Okay. Thank you. I didn't know that.
I mean, that does not mean that someone may not have another disability for which there's coverage, but that it is important to note just in terms of folks that you're working with. All
Yeah.
right. So why don't we go ahead and close the poll and see what people are thinking? All right, so it looks like the majority of folks said yes, that Mara is a person with a disability, and that is correct. So remember that under the Fair Housing Act, the definition of disability includes someone who has been diagnosed or has a record of a mental disability, which Mara does. Let's go to the next slide, and I'll turn it back over to Renee.
Great. Thank you. And so we're going to delve a little bit more into disability discrimination. And again, just really encourage folks to think about the reasonable accommodation process very broadly. And, I'll talk a little bit more about some of the responses that folks offered before. But part of disability discrimination, so as Natalie mentioned, disability is covered by the Fair Housing Act. And a part of what it means to discriminate on the basis of a person's disability is a failure to make what's called a reasonable accommodation. And so, what a reasonable accommodation is accommodations in rules, policies, practices, services, when these changes, right, may be necessary to afford somebody equal opportunity to use and enjoy a dwelling, so where somebody lives, right, which is what is covered by the Fair Housing Act. So a couple of very straightforward examples, waiving a fee or an upcharge for first floor unit because somebody uses a wheelchair and they need a first floor unit. And normally, the complex may charge a fee for that, but if somebody needs that first floor unit, the steps would be to request a reasonable accommodation. Now, if somebody is in a wheelchair, we'll get into a little bit about documentation and what steps can be taken to verify disability. And I'll get a little bit ahead of myself. If somebody has an apparent disability, that really is the end of trying to establish whether somebody has a disability, like someone who uses wheelchair. Assigned parking space. So, for example, if and both of these examples, just for illustrative purposes, have to do with folks who experience physical disabilities. But again, think about reasonable accommodations very broadly, and we've already talked about Mara's PTSD. Reasonable accommodations also apply to folks who have mental health challenges that would qualify under that definition of disability that Natalie mentioned. But assigned parking space, a reasonable accommodation there would be something like the complex normally doesn't have assigned parking spaces. It's kind of first come, first serve. But if somebody has a mobility impairment and they really need to have a parking space that is close to their unit, a reasonable accommodation would be providing an assigned parking space for that person, even though the normal practice, and you see the definition of rules, policies, practices, the normal course of business would be to just allow everyone to do first come, first serve parking. Next slide, please. So can Mara, just knowing what we know about Mara, can she request a reasonable accommodation? Yes, no, and I don't know. And we're going to launch the poll here, but folks are also getting in the chat, and that's fine too. But if folks want to answer in the poll questions so that we can just talk about the responses, and so let me know when you'd like to, when we get a good quorum and we can close it.
All right, we got about 50%.
That sounds good. And we got a couple in the chat as well, so I'll count those. But go ahead and close the poll. So what do folks think? Yes, and that is the correct response. Mora can request a reasonable accommodation. Um, Natalie went through, if folks remember, and we're throwing a lot of facts and facts into this scenario. But again, we want folks to be able to issue spot by the end of this training. So, Mara has depression, she has PTSD. And so reasonable accommodation, she's dealing with this issue of how the notices are being delivered in a way that really is triggering her PTSD um, and remember and keep in mind the effects that policy or that practice is having on Mara. She can't eat, she's having trouble sleeping, etc. Next slide, please. So, what is the process? So, we've established Mara can request a reasonable accommodation. And folks in the chat started getting to this, right? About what's the process to request a reasonable accommodation. The good news is, with respect to what the Fair Housing Act requires, there isn't a ton of, you don't have to say, I am making a reasonable accommodation, for example. But the process kicks off when the tenant, and it could be somebody else too, somebody could make a reasonable accommodation request on someone's behalf. But say in a typical case, the tenant tells the housing provider, I have a disability and I need a change I need a change to how notices are delivered. And I think somebody in the chat had mentioned, like, start a conversation with the property manager. So as I mentioned, there's not a ton of like strict requirements as to the form of a reasonable accommodation request. It can be written or oral. We would say that written is best. So a few folks had mentioned, request notice via email. So maybe make that request via email, right? Just make sure that, in terms of even though, what the law requires versus, what in practice will best help your clients, figuring out, a way to get this in writing. That way there's a record as well as, if the housing provider has some sort of reasonable accommodation process, you may want to avail yourself of that. You don't have to, which is important to note, but it may be, again, a way to kind of get that in the works and try to get that resolved more quickly. One other really important thing, a request can be made at any time. So the fact that Mara has already moved in doesn't mean that she can't make the request, right? Because the issue actually didn't even really arise until after she moved in. And it can actually, go all the way up through eviction. So, if there are purported lease violations or things that are jeopardizing somebody's housing security, think broadly and think about, does my client have a disability? And are there perhaps, changes to policies or accommodations that I can try and request to see if perhaps, we can avoid eviction or help, or even if my client ends up being evicted, maybe giving them more time to find other housing. But obviously, the goal is to really try and keep people housed when possible. Next slide, please. All right, so continuing our scenario. So some folks got ahead of me there, which is great. Mara sends an email to the rental office explaining, I have disability. Shouldn't say what it is. That's made worse by the unannounced knocking, by the delivery of the notices. And as folks intuited, she asked for notices to be emailed instead. And again, she doesn't label it, this is a reasonable accommodation request. In fact, she doesn't even know what a reasonable accommodation really is. She just is making this request. Is this still a reasonable accommodation request based on our conversation? Yes or no? And I think we can close it if we have a good number.
Where we just hit 50.
Excellent. Excellent. And so I would say yes, this is still a reasonable accommodation request. For a couple of the reasons that I mentioned. One, Mara doesn't have to, again, use the term reasonable accommodation. The idea is that anyone who has a disability should be able to request these types of changes. You don't need to, have a lawyer or have an advocate do it for you. And a lot of people may not even really, want to necessarily get into using terms like reasonable accommodation, et cetera. Um, yeah, thank you all for participating. This is really great. But it is still a reasonable accommodation, and we can go to the next slide. And one thing that I just wanted to note is in the scenario, we talked about how Mara didn't mention what her disability was, right? She didn't say, I have PTSD. She just says, I have disability. And, this is really interfering with my ability to access housing. And I want you to do, Y, which is I want you to email me these notices instead. So, what is the line there in terms of, what can the housing provider request in terms of verification? So I mentioned earlier that, if somebody is using a wheelchair and they are asking for, a physical accommodation like a ground unit, et cetera, um, you know, there really shouldn't necessarily need to be any documentation there because or verification there because somebody is readily experiencing a disability. One kind of gloss on that is if perhaps if there's like time limitations, et cetera, on that, but we can leave that if folks have like specific questions or scenarios about that. But generally speaking, if somebody uses a wheelchair, these types of physical accommodations, there really shouldn't be a verification. Um, so one thing to note is, again, the name and the term is reasonable accommodation, and this is going to be a very fact-specific, inquiry, right? What's reasonable in one context might not be reasonable for another, and we're going to get to that in a couple of minutes. But if the housing provider says, that's not reasonable, tells Mara, it's not reasonable for me to email a request, and I admit something like that seems like, that's not really, doesn't really pass the smell test that, doing something by email. But just say a housing provider says, no, that's too much of a change from the way that we do things, and I don't want to have to, um, do this process. Then, there's something called the interactive process. And our view, is that the Fair Housing Act requires it. Without getting into too much, there are some courts that say, it's recommended, et cetera. But I think in terms of the interactive process, it's a very important piece because as folks were doing things in the chat and talking about the different ways in which folks can communicate with Mara and get her this information, the interactive process actually, really introduces a way for folks to be creative and to think about different solutions, whether it's, you know, um, you know, email or figuring out different ways to communicate, and we'll talk about some other possibilities in a couple minutes. If the request is completely denied, tenants in federally assisted housing can use what's called the Section 504 mandated grievance procedure. We're not going to talk a ton about Section 504 today, but just know that in Section 504, oftentimes there will be a Section 504 coordinator, for example, who handles those types of requests. So that's definitely an avenue to think about as well if you know that you have a client or you're advocating for somebody who lives in federally assisted housing. And because federally assisted housing, overlaps with what Natalie's going to talk about in VAWA, that's another example of talking about federally assisted housing. But just to underscore, we're talking in this portion about the Fair Housing Act, which is going to apply much more broadly. So you don't have to have federal subsidies. As Natalie mentioned, the exceptions are actually quite narrow. Next slide, please. So we talked a little bit about this, and what can the housing provider request? Reliable disability-related information that is necessary to verify that somebody meets the Fair Housing Act's definition of a disability, right? So, and the need for the accommodation. And I think what's the most important piece of this is showing the relationship between the person's disability and the need for the requested accommodation. So, for example, if Mara's like, knocking on the door exacerbates my disability, and I am not able to feel comfortable in my home, that is showing a nexus. You can't necessarily just say, I have a disability and I need you to do X. It's very important to really show that intersection there to understand why the disability is needed. And it has the added bonus of perhaps minimizing, the need for asking, for additional documentation, et cetera. And there are limits on that as well. Next slide, please. So a housing provider can't basically be super intrusive and ask about like the nature, severity of somebody's disability, or create all sorts of hoops that make the request really cumbersome for somebody. They can't ask, do you have PTSD? How bad is it, etc. Like the fact that somebody has a disability, um, is and that they can then link it to the need is really what we're talking about here. And if, for example, the housing provider is like, I want medical documentation, if you're working with a medical provider, it would be something along the lines of, I'm treating somebody who experiences a disability and, they need this accommodation in order to be able to use and enjoy their housing. So it should be something along those lines while protecting the privacy of the individual so that they're not having to disclose all of this very personal information. Next slide, please. All right, so scenario time again. So Maura's rental office writes back and says proof of disability. So can the rental office do that? Um, is the rental office free to take Mara at her word? And can the rental office demand that Mara get proof from a particular physician? So, got a triple header here. And I think once we get to 50, we can close it out.
No problem. So we're at 21%. I know it's because it's multiple questions.
Oh, yes.
Almost there. We got about 8 out of 19, so about 42%.
Couple more, folks. And it's okay. I definitely want to make sure, Natalie, and we have time for questions. So feel free to close it out in the next 10 seconds or so, if even if we don't have our numbers. All right, awesome. So can the rental office do that? So, and again, reasonable accommodations pieces are, they are very fact specific. But generally, a housing provider can ask for some sort of supporting documentation. Again, unless it's, as I mentioned before, it's readily apparent, right? If Mara was asking for something related to her using a wheelchair, for example, where it's apparent that she needs a particular accommodation because of her wheelchair use, that would be one thing. So generally, they can. Of course, as with everything, it depends on how they do it, right? They can't be like, we want to see all of your medical records, for example. And generally, hopefully, the housing provider you're dealing with will have some sort of reasonable accommodation process in place where, they know what they can and can't ask for, but of course, that's not always the case. But if they just ask for additional verification, they can do that, but again, it can't be overly intrusive. And so it's going to be really case by case and in terms of like, how do they do this? But as a general matter, yes. Is a rental office free to take Mara at her word? Absolutely. And everyone agreed on that. And then third, can the rental office demand that Mara get proof from a particular physician? And no, Mara, as long as the request and, the information that Mara is providing goes to those factors about, you know, she experiences a disability, and it is interfering with her ability to use her housing and that it is that the accommodation she's seeking is necessary to ensure that she can access her housing. That should be enough, and she can go to the doctor of her choice. So that's important to note as well. Next slide, please. And when must a reasonable accommodation be granted? So it's necessary and reasonable for somebody who has a disability, right? Somebody who meets those criteria of what a definition of a disability is. And the change is necessary if it enhances the tenant's use and enjoyment of the unit by addressing the effects of the disability. Next slide, please. And so one other important point, the reasonable piece of this does a fair amount of work, for lack of a better way of putting it. And so, the change can't create an undue or financial or administrative burden. So, and again, a lot of this is going to be a case by case analysis, right? If you're dealing with a very small housing provider, what is reasonable for them versus like a large property management company, that may differ. Um, and it doesn't fundamentally alter the nature of the services it provides. So that leads into our next slide. Okay, great. And so when can it be denied? So the reasonable accommodation can be denied if the tenant poses a direct threat to the health or safety of others. So, one of the examples provided is if, somebody is using, like they experience a physical disability and they're using a motorized scooter, but the motorized scooter is posing a danger to other residents in some way. Or, if somebody experiences a mental health disability and they are threatening perhaps some of their neighbors. But importantly, this is an objective standard. So this means that the housing provider has to do an individualized analysis. They can't just assume, we talked a little bit about prior substance use disorder. And, the fact that somebody is in recovery is not there, that doesn't mean they are a direct threat to the health and safety of others, as an example, right? You can't rely on stereotypes, can't rely on just assumptions about people. There has to be concrete evidence that somebody is actually going to pose a direct threat to the health and safety of others. Next slide, please. Now, taking all of that together, we have sort of a little bit of a multiple choice answer here. Um, so we have a few accommodation requests. And I mentioned, advocates should really feel free to feel creative when thinking about potential reasonable accommodations. And then when the rubber hits the road about whether it's reasonable, again, is really going to depend a lot on context. So could we launch the poll, please? And I think it probably only allows you to select one. So I would just say select the most right one, and then we can go through all of these really quick. And I realize I didn't read off the answers. So which of the requests are likely to be considered reasonable? So Mara asks for the notices to be dropped off during hours when she is at work. She asks the staff to tape the notices to her door, but not to knock. She asks for staff to never be allowed within 20 feet of her front door. All of the above or none of the above. And how are we doing on responses? Oh, great, 65. Excellent. All right. So what do we got? All right. So folks did overwhelmingly pick what I think is going to be the most right answer. I mentioned that some of this is going to be context specific, right? And when I talk about that, I really mean the first one. Notices to be dropped off during hours when she is at work. Now, I think in most cases, it would be reasonable if Mara is working like a 9 to 5 job where, the rental office may be open, maybe there's property manager on site. But it would be perhaps unreasonable if Mara is only doing like ride share work. We mentioned, she's doing some gig work and maybe her shift is like 2 to 5 a.m. That's likely not going to be reasonable, right? Because most properties are not going to have a 24-hour staff. So I agree with the assessment of all of these. Taping a notice to the door is going to be the most likely to be reasonable, and I would say pretty clearly a reasonable request here since they're already going to the unit and just not to knock. Um, Mara asked for staff to never be allowed within 20 feet of her door. So that's going to be something that would likely create an undue burden or fundamental alteration, right? Like the staff at the property likely need to be able to, be around the unit. And so blocking folks from ever coming near her door is not going to be a reasonable accommodation. And now I'm going to turn it back over to Natalie.
All right, we'll give Renee a break and we're going to add some more to the scenario if we can go to the next slide. So Mara resolved the issue about notice delivery with the rental office, but her hours at her new job were cut. So she's been relying more on rideshare work to cover her expenses and for income. She lives in a city that relies on seasonal tourism, so her rideshare income has been inconsistent. She's fallen behind on rent. She's only able to afford most of the rent, but not all of the rent. So she's starting to accumulate late fees. One day, a fairly new rental office employee texts Mara that he could give her more time to catch up on rent and get rid of the late fees if she went on a date with him. Next slide. So we're going to shift here from talking about the focus on disability discrimination to sex discrimination, and particularly around sexual harassment in housing. So to be clear, sexual harassment is prohibited under the Fair Housing Act as a form of sex discrimination. And there are kind of two theories or types of sexual harassment that the Fair Housing Act recognizes. The first is the quid pro quo, so this for that, and we'll get into some examples here in a minute. And then the other type of sexual harassment is a hostile housing environment. And that is where the harassment is sufficiently severe or pervasive, so much so that it interferes with accessing or maintaining housing. Um, and the whether the harassment is meets the definition of hostile of creating a hostile housing environment really looks at the overall circumstances and takes them into account. So let's go to the next slide. So remember, the employee has asked Mara to go on a date, and she says no. And then after a few days, he texts her again, saying that she should reconsider. Mara decides to ignore the text messages, which are becoming more frequent. At first, she is annoyed, but over the next few weeks, the messages gradually become more pressuring. The employee says that unless Mara becomes his girlfriend, he will make sure that she's evicted for not being current on her rent. He also says that he is going to claim, even though it's false, that she has damaged her unit. So, based on these facts, could Mara assert that her fair housing rights were violated? And so we've got another poll question here for you. Just two options, yes or no. And once we get to 50%, we can close out this poll. Okay, so overwhelmingly, folks recognize that these facts, most certainly, under these facts, Mara could assert that her fair housing rights were violated. So we both have a quid pro quo kind of harassment here, where the employee is saying, "Go out with me, or I will evict you." Um, and then I think there's a question about whether it has risen to the level of being hostile. There's definitely an argument to be made that given the frequency of the messages, the increasing threatening nature of the messages, um, that it is getting there. But I think there's a question, and we don't have enough facts kind of in the scenario to understand to what extent it may be interfering with her access to housing. It's possible that it is, but we just don't have those facts with the pattern we gave you. All right, let's go to the next slide. And I'll turn it back over to Renee.
Thank you, Natalie. Oh, thank you, Natalie. All right. So, as has been a recurring theme, and we've talked about Mara's housing situation, she really needs to stay in her unit. We mentioned at the jump that her credit and rental history would make it really difficult for her to find a new place. Um, so Mara, agrees to have coffee with this employee who's been texting her. After the coffee, Mara's feeling uneasy. She really tries to avoid the employee. She ignores his texts, tries to avoid him around the property. But a week later, the employee shows up to her workplace unannounced and demands, why haven't you responded to my texts? She also suspects that the employee has entered her unit without notice and even searched through her desk. She's also seen the employee following her to the grocery store and around town. And one evening, Mara's suspicions are confirmed. She actually does find the employee in her unit. She calls the police. The employee is arrested. Um, so this is going to be more of a chat response, but based on these facts, what stands out to you? What rights could Mara assert? What creative advocacy approaches Could you maybe do to help more legal approaches in terms of, talking about the Fair Housing Act or just more broadly? Um, what would folks do if you had working with a client or advocating for somebody who was in in this situation? Don't be shy. You guys had really good responses earlier. All right, because I cannot stand awkward silences. There we go. Legal advice. Um, Safety transfers. Somebody does one more. And really just want this to be, thinking about, discussion. I do think legal advice and figuring out, under, state law, like what state protections might there be? Could Mara perhaps, yeah, landlord rights, stalking, and Natalie is going to talk about stalking in the context of VAWA, but even beyond that, thinking about, what sorts of legal protections apply and, at the state and local level, what remedies are available? Does there need to be a protective order of some kind? Somebody mentioned safety transfers, and again, thinking about what that looks like. In this context, where we don't have any evidence right now that this is a subsidized property. So thinking about, um, you know, what could that mean? And maybe it is, looking at state and local laws. So, without getting too far afield, um, many states have protections for survivors of stalking, and thinking about, like, is there early lease termination, even though again, that might be something that Mara might not want to do given how difficult it was to get this housing in the first place. Lock changes, those sorts of things. Think about, are there any state or local protections that might be able to help Mara here? Um, and any other advocacy approaches, or people had some good suggestions in the chat. All right, Natalie, I'll turn it back over to you.
Okay. So,
Oh, no, sorry. It's me.
oh, go
I
ahead.
apologize.
That's all right.
Yeah, so somebody had mentioned legal advice and kind of figuring out legal options. And so one of the things that we've been talking about for this portion of the training has really been around, what are Mara's rights under the Federal Fair Housing Act? What does that look like? And, here where we're talking about sexual harassment in housing and thinking about, in this situation, one of the prompts was, what stuck out to you? And I think definitely thinking about the escalation, right? And the extent to which, Natalie had mentioned before that, when it was just text, for example, is that really rising to the level of, the hostile environment, harassment in the housing context? Here, as you could see, the situation has escalated pretty quickly. So thinking about, okay, if I have a potential um, case of hostile environment harassment under the Fair Housing Act, which, as Natalie mentioned, is illegal. What are Mara's options? So one thing that Mara could do is file an administrative complaint with HUD or a state fair housing agency. So an administrative complaint is a way for folks to, um, make a complaint, but they don't have to go to court, right? So it's with a federal or state agency. Um, our suggestion would be to look to fair housing organizations where you are. The National Fair Housing Alliance, which is a national membership fair housing organization, has a member directory. And so thinking about if you are contending with this issue of, oh, I think that this is sexual harassment. I think that, my client or, whoever I'm advocating for, their rights have been violated. Talking to somebody at a fair housing organization or legal aid, somebody had mentioned, legal aid as well, can really help um, somebody talk through their options and figure out what makes the most sense. In certain states, there may be more, additional protections, for example, that, aren't necessarily spelled out in federal law. So it's always just good to talk to a fair housing organization, um, you know, or an organization that gets fair housing funding, to figure out what the best avenue is. The other avenue is to file a lawsuit. And there we also dropped the general link for legal aid and for law help for people to be able to find legal services. One thing that's important to note is that there are time limitations on fair housing cases. For the administrative complaint process, it's a year from the violation, and to file in court, it's 2 years. So, there's not a ton of time, particularly as you're thinking about, all of the other issues and, life that happens with folks. So again, if a fair housing violation is suspected, really try to think about one of these avenues. Next slide, please. And Natalie, I'm going to turn it back over to you to talk about the Violence Against Women Act.
All right, thanks. So just I kind of want to make a hard transition in people's minds because we've been talking about the Fair Housing Act, which applies broadly to lots of different types of housing. So now we're going to spend a few minutes just doing a high-level overview of the Violence Against Women Act. And it's important to note that VAWA, that's what we'll call it for short, only applies to federally assisted housing. Let's go to the next slide. So the Violence Against Women Act first added housing protections in 2005, and it was most recently reauthorized in 2022. So the housing protections in VAWA apply to survivors of domestic violence, sexual assault, dating violence, and stalking who either are applying for a federally assisted housing or homeless program or currently live in a federally assisted housing um, or participating in a homeless program. So important to note is that for survivors of human trafficking, you see that's not one of the four protected categories under VAWA. So for those survivors to be covered by VAWA's protections, they're going to need to meet one of the other four categories above, or as we'll talk about in a minute, be an affiliated individual of someone who is covered under VAWA. And so it's just important to know that while we may be able to make it fit, it just they are not explicitly survivors of human trafficking are not explicitly a protected category. Although there is work being done by a number of national organizations to get that protection added. So maybe in the next reauthorization. All right, next slide. So protected affiliated individuals are those folks, in addition to the survivor, that are covered by VAWA's protections, which I will go into detail about in just a minute. And so these kind of make sense. So it'd be people who probably might be living with a survivor or in a close relationship. So a spouse, a parent, a sibling, or a child of the survivor. An individual who stands in loco, to whom the survivor stands in loco parentis, or an individual tenant or lawful occupant that is in the victim's or survivor's household. Next slide. So there are a few kind of categories of folks that we get questions about. So one is, I told you the four categories of folks who are protected. We talked about who the survivors affiliated individuals are that are protected. But there are some other folks who may also be in in contact or staying with the survivor. So one is guests. So it's important to know that someone's guest um, is not an affiliated individual. So this might come up in a situation where, a tenant has a friend who's visiting, and while that friend is visiting, there is some sort of, domestic violence situation with the significant other. And then the next thing you know, that tenant gets a notice for a lease termination because of the domestic violence incident. So that guest isn't protected, and it makes sense. They wouldn't be protected because they're not on the lease, they don't live in the unit. Um, but the tenant who was living there will still be protected. And they can't be evicted because their guest was the victim of one of the what we call VAWA crimes, so like domestic violence, stalking, etc. What about live-in aides? So sometimes people with disabilities will have an additional person who lives with them to provide assistance related to maybe care needs or medical needs. So live-in aides are not included as affiliated individuals, again, because the live-in aides are not on the lease. And then what about the case of residents who are not on the lease? And so I bring this up because kind of when we're talking about survivors, um, in some cases, especially if you're talking about a survivor who is in a domestic violence situation or is the victim of economic abuse, they may be living with someone, and the person whose lease whose name is on the lease um, is the person who's causing harm and has refused to add them to the lease. So in that situation, VAWA protections actually would apply to that person who had been living at the unit who wasn't on the lease. And really this comes up, for example, if the harm doer I mentioned was the person who had the lease and they got arrested and were subsequently evicted, um, then that resident who is the survivor would still, under VAWA, have the opportunity to prove that they are eligible for that unit, because we're talking about federally assisted housing programs, um, all of which have their own eligibility requirements. So VAWA would allow them time to establish eligibility or to look for new housing while before the lease expires. Um, so let's go to the next slide. Okay, so I said I would get to this question about what housing VAWA applies to. So the federally assisted housing programs, VAWA defines as VAWA covered housing programs. So it's the typical HUD programs, the Department of Housing and Urban Development, their housing programs and homeless assistance programs, which folks are generally familiar with, public housing, vouchers, etc. USDA, which is the Department of Agriculture, also operates some housing programs for low-income renters. So those programs are covered. The Department of Veteran Affairs, or the VA, has a number of housing programs, primarily voucher programs that it operates that are also covered under VAWA. And then the Low Income Housing Tax Credit Program, which is a program that is out of Treasury, is also covered. And I want to flag that because we often one of the in the technical assistance that we provide, one of the common issues that we see is that owners of tax credit properties um, don't think that they are covered by VAWA, and they most certainly are. And so if you run into that issue, there's resources on HUD's website. I'd be happy to share with you if you haven't seen them, that explicitly provide that those tax credit properties are covered. And then there's also a catch-all provision, and that provision is important because it allows the agencies in between VAWA reauthorizations, if they create a new housing program or homeless assistance program, they can through notice or guidance or rulemaking, they can add that program to VAWA coverage, and they don't have to wait for the next reauthorization of VAWA. And then, just as I mentioned at the top of the VAWA section, the VAWA does not apply to private or market rate rental housing. Next slide. So, what are the protections that VAWA provides to survivors? So, the important kind of core protection is that VAWA says that survivors cannot be denied admission, they can't be evicted, and they can't have their assistance terminated because of violence that's committed against them. In addition, VAWA requires housing providers to give not only survivors, but anyone participating in their program the notice of housing rights under VAWA. So this is it's a HUD form. It's available online. And the importance of this is, how else would someone know that they were covered by VAWA if they didn't get this notice? And so VAWA provides for kind of three critical junctures in the housing process to receive that notice. So when someone's applying, when someone signs a lease, or someone receives a termination notice or eviction notice, they should get that notice. Um, a- Another important protection under VAWA is it provides protection against a survivor being retaliated against because they've exercised their rights under VAWA. Next slide, please. VAWA also allows survivors to use certain types of documentation to invoke those VAWA protections. And so what I mean by that is one thing that we often see is from, for example, a public housing provider, the renter will go in and say, I've experienced some form of VAWA covered violence, and they may get a response, well, that the person needs to go get a police report, or they need to get an order, they need to file for an order of protection against the harm doer. VAWA does not allow the housing provider to dictate the type of documentation that a survivor or victim submits in order to invoke those protections. So it is up to the survivor to determine. VAWA does provide for four categories of documentation that can be used, but again, with the survivor gets to decide which form of documentation they use. VAWA also allows survivors to request emergency transfers. And I will say, while this is an important right, it is one that has really not been successfully implemented. Happy to talk more to if that's something folks are dealing with offline about that. And then VAWA allows survivors to request that an abuser be removed from the lease and the housing where applicable. So that's what I was referring to earlier with the lease bifurcation. And we can go to the next slide. VAWA allows survivors to report crime or call for emergency assistance. So this was an important addition in 2022. There had been kind of a proliferation of these nuisance ordinances and crime-free housing programs across the country, which were punishing survivors who called 911 for assistance. So VAWA says that that cannot happen, and it applies not only to the survivor, it applies to anyone who's trying to call 911 or for emergency assistance. It protects their right to do that. As I referenced earlier, VAWA gives survivors the right to establish eligibility for the housing program if they were not the person who was um, initially receiving or the named participant for the program. And if a survivor participates in the Section 8 Housing Choice Voucher Program, they can keep their voucher and move with continued assistance. So I know that's a lot, and it's really just an overview. And again, I'm happy to um, talk more if folks have questions about VAWA. So let's go to the next slide. And let's bring it back to Mara. So, um, you know, when we were talking about the Fair Housing Act, we weren't sure if Mara was living in covered housing. But at this point, for purposes of this scenario, Mara is, it turns out, living in VAWA covered housing. So could she assert that she has protections under VAWA? Um, and we're just going to do this one in the chat. Folks want to chime in the chat. And what else would we need to know to figure out whether VAWA might apply to her situation? I get it. I got an emphatic yes from Chris. Thank you. Okay, so folks say yes, VAWA would apply. So yes, once I add the fact that we're um we're talking about federally covered property. Anything else folks would want to know to figure out whether VAWA would apply? All right. Well, while folks are thinking, okay, has the participant filed for an EPO? I'm guessing that's an order of protection. Um, so that we might want to know that. But the person does not have to have filed for a protection order in order to be covered by VAWA. One thing that would be important to know, because remember, it's limited to the 4 categories. So if the one question is, you know, did the level of stalking, was the stalking that she experienced, did that meet the definition of stalking under VAWA? The most kind of extreme fact pattern that we shared with you most definitely would. Um, Another piece, though, is because we know VAWA provides for housing protections. Um, is Mara still behind on her rent? Um, or is she at risk of being evicted? Because that's one thing, underlying VAWA is to protect someone's housing rights and to keep them stably and safely housed. So, you know, if she's still at risk of eviction for non-payment of rent, um, we may want to look into, are there local resources to help get her current on the rent so we can avoid that risk or alleviate that risk for her. Um, is there some additional job training that we could get her connected with so we could help her increase her income going forward? Are there other adverse housing actions that maybe Mara has experienced that we might need to deal with in this scenario? So these are all kind of things to think about. Um, and ultimately, there's a question about whether she might be eligible for an emergency transfer. So we would need to have a conversation about that. All right, let's go to the next slide. And then in terms of enforcing rights, so this is the VAWA is similar to the Fair Housing Act in terms of the enforcement provisions. So there may be HUD does have an administrative complaint process for VAWA, but again, would recommend contacting your local fair housing organization or legal services organization to kind of walk through what the options are and what makes the most sense, given, what if there are additional state or local protections. And then there is a question about whether VAWA can be enforced by going to court. It is often used as a defense in eviction cases to prevent someone from being evicted. Um, it's less tested and there are less court cases around whether someone can go to court and file a complaint alleging a violation of VAWA. Um, if it's not linked with other rights, such as uh, linked to the Fair Housing Act discrimination or a breach of the lease. If we're talking about federally assisted housing, there should be some sort of valid lease addendum. So I think with that, I will stop there. And I think I'll turn it back over to Rachel.
Actually coming back to me. That's okay. Yeah, so thank you. That was very informative and I think really helpful information. So thank you both Natalie and Renee. We wanted to just kind of leave a few minutes here and see if anyone had any questions. For the presenters at this point, you're welcome to come off mute or you can put it in the chat if there are any questions. We can read it. I also hate awkward silences, so y'all just let me know. I don't see anyone raising their hand or anything. So I think we'll just go ahead and close out then. If there are any questions after this, you can go ahead and email us here at the email address, our housing team email address. And we will also send out the materials from today and contact information for the presenters. So if other questions come up, then this is not like the last chance to ask them. There's also a QR code here for our resource library. We have a bunch of different info sheets, different tools, past webinars, a lot of helpful information in our resource library. So we just like to share that. And our final slide. Oh no, not the final one. Before that, these are some upcoming events that we have here at Freedom Network. So our next peer learning community call, I believe, is going to be actually a follow-up conversation of this webinar. So again, if there are more questions or more thoughts, anyone wants to talk more about it, we welcome you to join us at the next peer learning community call. There's a QR code there for the registration, and we'll continue sending out emails about that. Our next webinar is going to be on July 30th. And there's the QR code there. Sorry, I started reading Sade's message and I got distracted. So those are our next upcoming events. And then now we want to hold a few minutes as well to for you all to complete our evaluation about this webinar. Your feedback is really helpful in creating content and just for us to gather some information about whether or not it was helpful, what you liked, what you didn't like, and we can share some of that feedback with the presenters as well. And just thank you everyone for being here, for engaging in the polls and the chat. This was really great, and we just really appreciate all of you. Oh, and there's the link in the chat if the QR code is not the way you want to do it. I'm also just going to drop this in the chat. If anyone wants to request a training certificate, you can send us an email and we can do that for you as well. Thank you, Sandra. Thank you, Alicia. Thank you, Amanda. If let me make I'll keep notes of who is requesting. And once you're done with the evaluation, feel free to pop off. And again, thank you so much for being here. And thank you.
Yeah, Natalie and Renee, that was really great, really helpful. Very,
Yeah.
very, yeah, lots of good info. Thank you.
Thank you for having us.
Yes, happy to be here. Glad it was helpful and relevant to folks.
Just echoing what Rachel said, very, very informative. I'm really excited to get the recording out to folks. Yeah, just thank you so much. It actually makes me excited about the info sheet we'll be sending too. Just think this information is so relevant when it comes to like advocacy at this point in time. So powerful.
Yeah, and thank you both for your feedback on that too, because we've been working on that for a little bit, so really appreciate that.
All right, I think we can go ahead and close it up. Have a good afternoon, everyone. Thanks. Bye.
Bye.